Good morning, everyone. It is a privilege to be back here. Limitation of liability, it is a fascinating subject, and we can spend weeks talking about it. We only have 1 hour. I realize that there are some students, but there are a lot of familiar faces. So I decided that whereas there has to be some element of repetition of what we have done in past years, I wanted to go a bit more, let's say, faster in the basics and a bit more practical to a certain extent to make it a bit more interesting. Inevitably, we have to start with what is limitation of liability. And limitation of liability for maritime claims is basically the rule that allows those who are parties to the marine adventure to cap their financial exposure up to a certain limit, regardless of the amount of claims that are brought against them. An early example, the Titanic, which we all know. Claims for loss of life in the sinking of the Titanic amounted to $22 million. Of course, doesn't sound a lot at this time, but at the time it was a lot of money. But the fund that was constituted for limitation purposes was based on the value of the vessel, which comprised a number of life sailboats and unpaid passage monies, and that amounted only to $91,805.54. There's a huge difference here. And this in itself tells us calculated on the value of the vessel, which we will come back to that. So this is an early example, and it actually shows us the limitation of liability has been for a while, but now it may be more important than ever. We had very recently, in 2021, in March, the grounding of the Ever Given, which blocked the Suez Canal for nearly 6 days. And it actually faced claims of around $961 million, including a claim for $300 million for loss of reputation. So limitation of liability will tell us basically how much of these claims are going to be paid. So as I said, the ability of the ship owner to limit his financial exposure, regardless of how many claims may be brought against him. And when we deal with the limits of liability, we'll see what actually happened in this case. Even more recently, the Baltimore Bridge collapse on 26 March, a container vessel ran into a pillar of the bridge of the Papatsko River in Baltimore, bringing part of the structure down, and with them, some people that were in cars that were on the bridge at the time, causing, of course, loss of property and damage to property, as well as loss of life and personal injuries. The name of the ship was the Dali, which was flagged in Singapore, and the tonnage was 95,128 tons. As we will see shortly, tonnage is imperative when it comes to limitation of liability. So it was said that with various owners and companies involved, and with some maritime laws that even predate the sinking of the Titanic, the untangling web, figuring out who owes what, in addressing the damages for both lives and to physical structures will be complex. And it was said also that this claim has the potential to be north of $1 billion, and litigation will run for years. But the question is, where? And what direction will this take? And this is something that it will be quite interesting, we'll address afterwards. One of the interesting things is that when we talk of this, we're talking really of maritime catastrophes, fine, whether loss of property, whether loss of life, etc. But at the same time, we're talking about global limitation of liability. And global limitation of liability must be distinguished from what I had called particular liability regimes. The LLMC convention that we will be discussing today is not a liability convention. Who is liable? What are the bases of liability, etc.? We have to find it elsewhere, whether in contract, tort, or any other law. This only tells you who can limit liability, for what, up to how much, etc. We'll discuss. Other conventions have been created with particular aspects in mind, carriage of goods by sea, carriage of passengers by sea, etc. I'm not going to go into that because it will be discussed afterwards, but those have a particular element. What we're talking today is that global limitation of liability. If we were to study the history of limitation of liability, it has a long history. But I want to focus just on three types of limitation because of the time constraints. Limitation of liability by abandonment, limitation of liability by tonnage, and the American system. The Belgian system, just to tell you, was something a bit of a compromise that led to the first international convention. So it will be somehow touched upon, but I want to focus on those first three. Limitation of liability by abandonment. What this meant is that the ship owner was actually personally liable for the losses, but he could limit his liability by abandoning his ship and freight of whatever was left of it to the claimants, and then they had to fight out against the vessel. But the ship owner was released from liability. So his liability was limited to what was left of the vessel. That's why I still kept that example of the Titanic, that we said that the limitation fund that was constituted was based on the value of the vessel. The vessel had sunk. So what was the value of the vessel? The saved lifeboats, the money that was not paid, etc. What was left of it? So he's personally liable, but he's released from liability by abandoning his ship and freight. This is the traditional way in which limitation of liability started in the civil law countries. Okay. On the other hand, in the UK, limitation of liability at once started by reference to tonnage. And in this case, it was based on the tonnage of the ship, regardless of its value. And as from the 1862 Act, the limits of liability were set at £15 for loss of life and £8 for loss of property. So in the civil law system is what's left of the ship, in the common law system based on the tonnage of the ship. The American system was very peculiar. The American system is born out of the fire on the USS Lexington, and it leads to the Limited Liability Act of 1851. This is what remains till now in force. Question is, why have the Americans not decided to join any later convention, etc.? Big question. One of the arguments is that they are afraid that if it is repealed, this act, and the question brought to Congress and Senate, that it will not pass and limitation of liability will be abolished altogether. So better to have something than to have nothing. But still, the law now is codified in 46 US Code sections 181 to 189. And this system aimed at establishing the limit of the ship owner's liability based on his interest in the marine adventure. But what is his interest in the marine adventure? In principle, the interest was the residual value of the ship and freight. So it would seem that in first instance, the American system adopted limitation of liability by abandonment. However, the system was later modified to allow the ship owner to limit his liability by posting a bond in the amount of the appraised value of the ship and freight, a value, the security, what we would now know as the fund, to replace the vessel. But it was still based on the residual value of the ship. So it's still a form of limitation of liability by abandonment with a twist. Is that clear? Now, from all this, I want to come back to one case, which is very peculiar. Lord Denning I think this is one of the most celebrated statements in the discussions on limitation of liability. He said, in the case of the Bramley Moore, that limitation of liability is not a matter of justice. It is a rule of public policy that has its origin in history and its justification in convenience. Now, I have discussed it even in the past. I'm not going to touch upon it here because we changed a bit the structure of the lecture, whether it is true that it's not a matter of justice. Because if we go into economics and philosophy, there's a principle of distributive justice that would allow discrepancies in wealth so long as the lesser members of society are benefited. So if the ship owner can save money, if the ship owner can limit liability, but the rest of society is benefited, it would still be allowed. So that is a bit of a question. But in reality, what this tells us is that for you that are the claimant, it will not be a matter of justice because you will not have your claim satisfied in full. So what claims are paid and what claims are not paid in full is precisely what limitation of liability will tell us about. As Igor mentioned before, we're touching upon the anniversary of the 100th anniversary of the Hague Rules. And in fact, the convention was adopted on 25th August 1924. And curiously, because of those who are here present, several heads of state concluded this date, including His Majesty the King of the Serbs, Croats, and Slovenes. So from this region, there were signatories to the original Hague Rules. Now, just touching upon it, because it seems that we're veering out of the topic, if a car is damaged in a container while being carried by sea, or a couple of containers are lost overboard, etc., there will be claims of limitation of liability. But limitation of liability would not be under the LLMC convention that we will be discussing today, would be done probably under the Hague Rules or its successor, the Hague-Visby Rules, etc. And it would be usually per package or unit, nowadays even in the Hague-Visby Rules, even per weight. But this is a particular liability regime. This is not what we're here to talk in this hour. So why did I mention it? It saddens me, to be honest, that there are full conferences around the world being convened to celebrate the 100th year of the Hague Rules. But it is often forgotten that on that same day, that same conference adopted the first International Convention on Limitation of Liability of Ship Owners. That the first global limitation of liability was adopted on that same day. Nobody has mentioned it. Everybody's celebrating the Hague Rules, nobody's celebrating it. Curiously, we have moved on, and that's why the title of the lecture was 100 years on, but the convention is still in force in several countries. Brazil, for example, Madagascar, Turkey, which is something curious, because Turkey is still a party to the 1974 convention. I'm not sure, I didn't check this morning if it was party of the 1956 convention, but Turkey is a party to the 1924 convention, 1976 LMC, and 1996 LMC. It's a party to all of them. So it's a bit of a mess when it comes to a potential conflict between different conventions. After that, things were changing and rules needed to be expanded a bit. Particularly, we will see in Article 1.4 even, there was a case called Adler versus Dickinson. And sorry, am I moving too much because of the camera? So sorry, I'm giving you work. Okay. A case called Adler versus Dickinson came to the fore where the claimant fell off the gangway and had a fantastic lawyer, and the lawyer told her, if you sue the owner, he will limit liability. Sue the crew. And the court said the owner did not sign on behalf of the crew, so they have to pay full liability. There was a huge clamor, and not only was the 1957 convention adopted on those terms, but a very interesting clause emerged in carriage industry, which, from the name of the ship, I'm sure you all know that, is the Himalaya clause. The ship was the Himalaya. So the 1957 convention, or just going a bit before, the 1924 convention brought about a compromise, giving the option to limit based on tonnage or abandoning the ship. In other words, civil law and common law. The 1967 convention focuses already on tonnage. Okay, was a bit more successful than the 24, not as much. Bigger ships were being created, limits of liability were being eroded, and a particular case brought the attention of the international community, the Tojo Maru. There was a salvor, that had to work as a diver and was instructed to wait until given instructions to fire his bolt gun until the holes were degassed. He didn't wait, fired the bolt gun, it was a huge explosion. And when the case went to court, the House of Lords found that the accident happened not on board the tug, not on the management of the tug, completely away. So there could be no limitation of liability as ship owners. So the salvors industry brought a very powerful lobby, and the 1976 convention now includes the right to limit liability independently of salvors. So that's the 1976 convention. It was adopted, as I said, in 1976, and it brought quite remarkable changes. Limits of liability were increased. They were safeguarded by the use of the special drawing right. And most important, as we will discuss here, the right to limit liability was lost in a much stricter test than before. The limits of liability were still being eroded, and 20 years later, it was found necessary to adopt a protocol to the convention, which has taken over now, and most states are parties to the 1996 protocol. It increased the limit of liability, and very importantly, included a tacit amendment procedure. It was no longer needed to convene a conference to increase the limits of liability. And based on this, the IMO Legal Committee adopted Resolution Leg 599 on 19th April 2012 to increase the limits of liability of the 1996 protocol. And these are the limits of liability that are now in place that entered into force in 2015. In fact, we have seen there has been a transition. The concept comes from time immemorial. First, international regulation is adopted 100 years ago. It has continued to evolve. It has been under attack. In fact, this which was it? Let's see. The amendments of the limits of liability actually came out from an Australian proposal, from an accident that happened from a bunker oil pollution on board a ship that was called the Pacific Adventure. In fact, the question whether bunker oil was excluded or not was still subject to debate before. This was actually the basic clause to increase the limits of liability, and it is clear that now it is accepted. So at the time, there were almost calls for the abolition of the concept. It's not going anywhere in the near future. In fact, it will be evolved. And the work of IMO now is on what are the bases to monitor and increase the limits of liability if and when needed. So let's discuss briefly the LLMC convention as amended. In other words, the 1976 convention as amended by the 1996 protocol. Article 1 deals with the persons entitled to limit liability. It includes first the ship owners. Now, if you have studied the CLC and other conventions, you would have seen that every convention is subject to interpretation, and the meaning of every term depends on which convention you're talking about. So, for example, if I tell you what is a ship, I cannot know what is a ship depending on the convention we're talking about. You know, Bunkers Convention, any craft whatsoever, CLC, tankers. You know, so it depends. Ship owner as well. The term ship owner, when you deal with the CLC, is the register owner. In the case of the LLMC, it has a wider definition. It includes the owner, it includes the charterer, the manager or operator of a seagoing ship. I'll come back to all this now. Now, it also includes salvors, as I mentioned. They have an independent right to limit liability. And also, as I was mentioning, from the case of the Himalaya, but now without different wording, in 1957, it was extended to the servants of the owner. Now it says any person for whose act, neglect, or default the ship owner or salvor is responsible. That's a very wide word. And then the last person is an insurer of liability to the same extent as the assurer himself. So, for example, the shipper is not entitled to limit liability. Okay. Now, when it comes to the term owner, as I said, it's not limited like the CLC to the registered owner. It can be the registered or beneficial owner. It can be a part owner of a ship, all owners. Before going into the other categories, some important points. Trying to avoid parties trying to circumvent the provisions of the convention by, instead of suing the ship owner in persona, suing the ship in rem, the convention makes it clear that in this convention, the liability of a ship owner shall include liability in an action brought against the vessel herself. And also, very, very, very important, you would imagine that my ship causes damage. And I fight it, and in the end, when I am found liable, I say, okay, I'm liable, but I would, instead of 10 million, I will limit my liability to 5. You would expect that that is how it works. But limitation of liability is one of the first discussions you will have in the case of a major incident, not at the end. So, actually, this is safeguarded by saying that the act of invoking limitation of liability shall not constitute an admission of liability. So, you will see that from the beginning, you caused me damage. You say, okay, but I'm limiting my liability. So that doesn't mean I am liable. That just means, okay, I cost you 40 million in damages. According to the size of my ship, the limit of liability is 20 million. Forget your 40 million. Let's start our discussions from 20 million down, because that's as much as you're going to get. So it's a tool also for negotiation, but it does not mean that you are admitting liability. So owners we mentioned, charters is mentioned to cover them all. Bareboat charter, time charter, voyage charter. But a curious thing came in the case of slot charters, because slot charters charter just a space. Imagine this classroom, even here, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. You have 10 desks just in this area. So we have around 25 desks. Imagine this is a ship, can carry 25 containers, 25 desks. So I can be a charterer and charter the whole thing because I need to carry 25 desks. Or if I need regularly, Ridian has this ship, and I said, Ridian, I'm going to charter the space of 5 of these desks.
Too expensive.
Yeah. So you say it is a slot charter. So can he limit liability or not? It was a question, actually. In England, it was decided in the Napoli that in accordance with the ordinary meaning of the word charter and in light of the evident object and purpose of the convention, a slot charterer is within the definition of ship owner and therefore is entitled to limit liability. I'm not saying that it will be accepted in every country. In fact, CMI had issued a questionnaire and there were a number of countries that had objected to it. Not sure how they are handling it now because it was some time ago. Yeah.
Slot charter means bareboat charter as well? Or...
No, bareboat charter, I'm chartering the whole ship. In fact, you are the owner. And I tell you, listen, I'm taking over your ship and I will run it. I will put my crew, I will put everything. All you have to do is put out the hand and I will give you the money. In fact, if the vessel salvage is another one, I will be entitled to the salvage, not you as owner. If it needs repair, I will be repairing it, not you. So I act as the owner in the bareboat charter. That's why in fact, in the 1957 convention, it was called the principal charter because he acts as owner. He literally takes over the vessel. In fact, it's quite curious. When I teach carriage for charter parties, I ask how many types of carriage charters are there? And everybody tells me 3. And I said, no. And said, no, 3, yes, there's voyage, time, and bareboat. But bareboat is not really a carriage charter. It's a lease of a vessel. Exactly, that is the owner, exactly. The slot charter, actually, as I said, it comes out from the space sharing agreements of the Americans. And you have a liner every week and you need some space and you charter just a part of the ship, but you have no power to decide where to go, etc. It's similar to a shipper. Let me put it like that. In fact, I had some slides here, but I deleted them because we don't have time. That it could be very similar to a volume contract. In fact, I'm sorry I deleted the slide, but now that it came up, imagine that I do a contract, a slot charter party for 20 containers every week for the following 6 months. Okay? That's a slot charter. Now, I do another contract for the shipment of coffee bags that will occupy 20 containers every week for the next 6 months. That, under the Rotterdam rules, would be a volume contract. The first one is a slot charter. I use coffee, but it can be anything else. Those containers cause damage and I am liable. Can I limit my liability? Under the slot charter, I can. Under a volume contract, I'm a shipper. I don't fall within the definition. So the same set of facts, but different contractual entity, different results. And it can lead to a bit of injustice. But slot charters now in the UK are deemed to be entitled to limit liability. Now, the only thing to mention is that the convention says that if I as owner or Susanna as charter or Igor as insurer constitute the fund, that constituted fund covers everyone. It's like constituted by all. So if the slot charter is allowed to limit liability, he cannot be allowed to limit liability just based on the space he's sharing. He's chartering. He will limit liability based on the overall tonnage of the ship to protect everything. Managers or operators, the convention does not define them. Greeks, William and Farr, for example, used to say that crewing agents are not entitled to limit liability because they don't have an interest in the whole of the ship. But if you see here, in the case of ASP Ship Management versus Administrative Appeals Tribunal, the full Federal Court of Australia found that operated by, in other words, included operator, as used in the Navigation Act, encompasses notions of real, substantial, and direct role in the management and control of the commercial, technical, and crewing operations of the ship. So it depends. There are different contracts, crewman A, crewman B. I am an agent of the owner, or I am tasked to crew the ship myself. It depends on the role of the agent to determine whether he's entitled to limit liability or not. So it is not certain. The convention just says managers or operators. The question you have to address in each court is, does this person fall within this term? Salvors, as I mentioned, now they have an independent right to limit liability, and salvor is defined as any person that is contributing to the salvage operations, including wreck and cargo removal. Now we go to the case of the Himalaya that I mentioned, but it is now broader. The convention in Article 1.4 says that extends the right to limit to any person for whose act, neglect, or default the ship owner or salvor is responsible. It doesn't say they are servants of the owner. The ship owner has to be responsible for their involvement in that. So, for example, the crew is responsible, they're the servants. What about stevedores? In the case of the White Rose, the court said that the ship owner cannot hide. If he has undertaken the duty, he cannot hide behind the fact that he engaged an independent contractor to avoid liability. It's his duty, and that will not change. So the stevedores that owner would be responsible for the stevedores, hence the stevedores would be entitled to limit liability. Ship repairer or shipbuilder is responsible for the seaworthiness of the vessel, which under the contracts is a responsibility of the owner. So I very like much the wording of Aleka Mandaraka Shepard, who says that basically to be entitled to limit liability, these persons would be performing a non-delegable duty of the ship owner. Okay. And then you have the liability insurer that will be entitled to limit liability to the same extent as the assured himself. This is quite interesting because assured can limit, ship owner can limit. Assured cannot limit, assured cannot limit, insurer cannot limit. Of course, if the assured cannot limit because of a willful conduct, the insurer will not even be liable. Now, this is a bit different than most modern liability conventions, that when they require compulsory insurance, they include a right of direct action. And if you sue the insurer, he will be entitled to limit liability whether the assured can limit or not. LLMC is to the same extent as the assured himself. So those are the persons that can limit liability. But the question is for which claims, not for every claim. Claim subject to limitation, because we have to be a bit brief. loss of life or personal injury, and loss of or damage to property, and consequential loss resulting therefrom. So, and it says, loss of life or personal injury occurring on board the ship or in direct connection with the operation of the ship. So what do we mean in direct connection with the operation of the ship? Let me give you this example. There's this cruise here, and these persons are walking next to the cruise line, okay? One of them dies here, in the quay. One of them dies. Is the ship owner liable?
No,
Huh?
no, because it wasn't direct correlated with that ship.
Well, you know, my students laugh at me because my favorite answer is it depends. You know, if he dies, this person dies of a heart attack, no, shipowner has nothing to do with it. But if one of these lifeboats fall on top of him, then it is. So Rich J in Caspian Basin versus Boygas number 4 said that indirect connection with the operation of the ship is the way in which the convention expresses the necessary linkage between the loss of or damage to the property on the one hand and the ship in respect of which the claim is to be made on the other. You know, there was a case in Canada, I remember, because it's any craft, so even canoes, kayaks, and everything. So there was a kayak was being used, finished, you know, they put it on board of the truck, they're tightening it. One of the guys is about to put it, doesn't put it well on the hook, the bungee cord lashes out and took out the eye of another one. You know, there is suit, can he limit liability, etc.? And I said, no. Why? If it would have happened in the water, it would have been in direct connection with the operation of that ship, okay? But here, there's once it is put and it's being secured, it has become an item for road transport, and it's covered by the road rules, not by maritime law. So in direct connection with the operation of the ship will help us identify what is the link between the ship and the claim. Claims in respect of loss caused from delay in the carriage of cargo, passengers, or their luggage by sea. Now, when the conference took place, there was a strong debate whether this was needed or not. Because, of course, if it says loss of or damage to property and consequential loss resulting therefrom, delay could be the consequential loss. Like, for example, take the Ever Given. The Ever Given had a loss of property or damage to property, etc. Definitely 6 days stuck, and with anything that happened afterwards with the arrest, goods are delayed. So that delay could fall from Article 21A, consequential loss resulted therefrom. That was known as concrete damage. But there was also the possibility of abstract damage. This is the queue of vessels that was waiting in the Suez Canal for the ship to be unblocked, for the canal to be unblocked, rather. So they had no loss of or damage to property whatsoever. Yet still there were delays and there would be claims. So they would be entitled to limit liability under this article. Then there is claims for infringement of rights other than contractual rights. So, for example, if there's no payment of freight, that will not be covered because freight is contractual. What this means is, for example, the right of easement. Imagine that a railroad track company may enjoy over this bridge, which is broken by a ship. A ship capsizes at the mouth of the port and blocks the entrance of the port. That may be listed as well as infringement of rights other than contractual rights. Now, two very important claims, and I mentioned very important because these claims may be taken out of the concept of the coverage of the convention by means of a reservation, are wreck and cargo removal. Okay, so wreck removal and removal of cargo are covered by the convention, but may be excluded, as I will mention later on, by means of a reservation. In fact, under the 1976 convention, it was the only possible reservation that could be made. And then this is a bit complex. I'll just try to briefly mention it. Claims of a person other than the person liable in respect of measures taken in order to avoid or to avert or minimize loss for which the person liable may limit his liability and further loss caused by such measures. Imagine that a chemical container tanker is suffering danger, and for this case, the ship owner is entitled to limit liability for any pollution caused. But there is a third party that very diligently tries to avoid chemical pollution and goes and assists the vessel. But this third party causes further loss, and he then claims compensation from the ship owner. That would be a claim from a person other than the person liable for a type of claim from which the person liable would be entitled to limit liability and therefore would be subject to limitation, even in respect of further loss caused by this person. And these claims, it says, can be subject to limitation whether brought directly or by recourse or indemnity. Okay. Oops, I have to rush. Claims accepted from limitation, salvage claims, and contributions in general average. Here, we're speaking of direct salvage claims. For example, imagine in this ship, the salvage of the ship itself is paid by the ship owner, and it's a ship salvage claim, not subject to limitation. The cargo owner has to pay for the salvage of the cargo, and it's not subject to limitation, but it's possible. Why should I pay? I did nothing wrong. So actually, he sues the ship owner for indemnity. But the cargo owner's claim for indemnity would be subject to limitation, even if it is because he paid salvage claim. And it is because the cargo owner's claim against the ship owner is no longer a salvage claim. It is a claim for breach of the carriage contract. So technically, what we're talking that are excluded are direct claims from the salvor. Another claim that is excluded is the claims within the meaning of the CLC. So whether you're a party or not, whether compensation is payable under the CLC or not, is not important. If it is a claim for oil pollution damage from a tanker, in other words, within the definition of the CLC, LLMC does not apply. Nuclear claims are also excluded, as well as claims for loss of life or personal injury that are brought by the heirs or dependents of the seafarer, let's put it like that, but only if the law of the country prohibits limitation of liability or imposes limitation of liability at a higher level. So if there is no such restriction, limitation applies. But there are some employment laws in countries that would prevent this type of limitation. So the convention will leave it to the national laws. Now we know who can limit and for which claims. But there may be circumstances in which the ship owner may lose his right to limit liability. Originally, under the 1957 convention and before, the right to limit was lost by the fault or privity of the owner. This brought Gilmore and Black, two American writers, to say basically that that privity was an empty container in which courts could pour whatever content they will. In other words, you fall before a judge that likes limitation, there is no fault or privity. He doesn't like limitation, there is fault or privity, there's no limitation. So it was very peculiar. LLMC convention changed this by a much stricter test, which we will see in the next slide. But I just wanted to point out here that it is the same test used in most liability conventions nowadays with such small variations. LLMC speaks of a person liable, Athens speaks of the carrier, CLC speaks of the owner. LLMC speaks of the loss, here it speaks of the damage, here it speaks of pollution damage. So subject to these small things is the same test. And what is the test? It says that a person liable is not entitled to limit liability if it is proved that the loss occurred from his personal act or omission, committed with intent, or recklessly and with knowledge that such loss would probably result. Committed with intent, it says recklessly and with knowledge that such loss would probably result. We could spend the whole hour discussing this article, but I will go past it just to say What do we mean by reckless? Just to get an idea, Goldman versus Thai Airways said that when a person acts recklessly, he acts in a manner which indicates that a decision to run the risk or a mental attitude of indifference to its existence. In other words, you realize there's a problem, say, what the hell, let me go ahead. That's recklessness. But recklessness has to be paired with knowledge that you will cause that problem. Imagine, I'm navigating, I'm the master of this ship, okay? It's carrying a lot of bunkers and it's carrying cargo. Listen to what I'm saying, I want to deliberately run the ship aground so that I lose the cargo. I run the ship aground deliberately and the cargo is lost. Can I limit my liability? No, because that's what I wanted. Now, when I did that, I never thought it would happen, but the bunker holes breached and I caused pollution damage. Can I limit liability? I cannot limit liability for the containers, but I can limit liability for this. Very subjective, very. The right to limit was meant to be virtually unbreakable when the convention was adopted. A number of French courts started breaking the right to limit. I don't want to use the word rather easy, but in a way that annoyed British lawyers. And English commentators were saying that the French didn't know what they were doing, that they were fishing for facts, etc. And then the Saint-Jacques number 2 came to the fore before the courts of England. And Grosjean denied an application for summary judgment in the case of the Saint-Jacques when it collided with the Gutiérrez, because he considered that if it went to trial, there was a strong possibility that limitation of liability would be broken. And this was because the Saint-Jacques number 2 decided not to follow the traffic separation scheme to get to the fishing ground, but decided to navigate the wrong way across the traffic separation scheme, knowing full well that there were a number of vessels coming in this vicinity. So there was a real possibility. The case was settled out of court. But there was an alarming situation for the international community that limitation of liability would be broken at any minute. Creates a lot of commercial uncertainty, a lot of money. IMO can do nothing about it itself because it's up to the courts of each state to determine. But IMO then worked towards a unified interpretation of this test. And I actually changed the wording because, in my opinion, the wording, when I thought that English was wrong, I'm to take note of this anyway. It says, on 15 December, the slide that you received said the IMO Assembly adopted this resolution. But I changed it to say 3 resolutions on the unified interpretation to break the right to limit liability were adopted at the Assembly. Because in reality, the resolutions are adopted by the state parties to the convention, not by IMO. So it's what we know as an authentic interpretation of the treaty. There was resolution 1163 on LLMC 76, resolution 1164 on 96, and resolution 1165 on the CLC. As I said, they apply the same principle. One thing, I am not satisfied with the explanation that I have been given, but one thing that I find curious is why did they not make one for Athens if it's the same test? It could say, because it's the same thing, but I could argue, if it's the same wording, but you left it out, it's because it deliberately is intended to mean something different. It can actually give rise to litigation in court, in my opinion. Now, the resolutions are quite long, 21 recitals, 3 paragraphs, but they only have 1 substantive paragraph. And it is meant business. It says, it affirms that the test of breaking the right to limit as contained in Article 4 of the 76 Convention is to be interpreted as virtually unbreakable in nature. That's what it was intended on. Breakable only in very limited circumstances and based on the principle of unbreakability. It means a level of culpability analogous to willful misconduct. In other words, a level higher than the concept of gross negligence, which was rejected in the conference, a level that will deprive the ship owner of the right to be indemnified under their marine insurance policy, and a level that provides that the loss of entitlement to limit liability should begin where the level of culpability is such that insurability ends. Now, these words are so strong and so important. Why? Because if it is interpreted like that, means that if the right to limit is broken, there's no insurance. So by now, you may have a Pyrrhic victory, if at all. You say, I won, but there's no insurance to cover it. So it has to be extraordinary circumstances. The term recklessly has to be accompanied by knowledge. There was a case in which the court said they have to stand or fall together. And the two terms establish a level of culpability that must be met in their combined totality and should not be considered in isolation of each other, if at all, to understand each concept, but they have to be together. And that the conduct of the parties, other than the ship owners, for example, the master, crew, etc., is irrelevant for this purpose. So this is a resolution. It has a quasi-binding effect because it's not a treaty, but it was taken in the largest forum, adopted by the state parties themselves. So if the state party was there, is voting, etc., well, not voting because it's by consensus, but it's represented there, it can be an expression, now turning away from maritime law and purely public international law, it can be an expression of the opinion juris of the state, which automatically binds the state, because if not, it would have objected to it. So what is the effect? It is expected that the IMO resolution will promote legal certainty, and by recognizing the right to limit is meant to be virtually unbreakable, courts should not feel free to break the right easily. In fact, there have to be extraordinary circumstances to break the right to limit. And in turn, it provides legal and commercial certainty. Why? Because insurers will know that their financial exposure is guaranteed, let me put it like that, and like that they can maintain competitive rates in trade. That's insofar as the loss of right to limit liability. Counterclaims, it just means that when you have two ships that contribute to the same act and they have claims against each other, basically not each invokes the right to limit and then you set off, but you first set off the claims, and then if there is a balance, you limit liability. For example, you have here the claims of ship A against ship B are $13 million. The claims of ship B against ship A are $3 million. That doesn't mean that they both limit liability and then they set off. What it means is that you first set off the claims, leaving a balance of 10 million, limitation of liability then is invoked by ship B for those 10 million that are left. If the tonnage is small, 4,467, the limit of liability for property claims will be around $1.145 million. Or if it's the 1996 protocol, around $4 million. So that means that less than half the claims will be paid. So if there are two or more ships and they all contribute, the claims will be set off, and if there is a balance, there will be limitation of liability involved. Is that clear? Now, so now we know all this. How much is the limit of liability then? Now, this is found in Article 6 and 7. Article 6 contains the general limits of liability. There are two types of limits of liability involved. In Article 6. One, in respect of claims for loss of life or personal injury, and 6.1b, any other claims. In fact, when literature often refers to it as property claims, but it's not exactly a case, because a bunker oil pollution claim may not necessarily be property claim, or there may be other claims, infringement of rights. So it's any other claims, it says. The limits of liability, as opposed to earlier versions that was just X by the number of tons, is in a sliding scale, and the bigger the scale, the less amount they pay per ton. So bigger ships pay less per ton than smaller ships. And you can see them here. I'm just going to go through them. 3.02 million for the first 2 tons, and then for each ton in excess, there are different stages, and you have to go through all of them. What is important to know is that these amounts for loss of life or personal injury are twice as much those of any other claims. Okay, so those are the limits of liability. You have 2 limitation amounts, one for loss of life or personal injury, and one for any other claims. Now, sometimes the fund for loss of life is not enough. So there is Article 6.2 that is known as the overspill provision. For lack of a better picture, I put this because when it overflows, it flows down to the next. So what this means is that when the amount calculated under 618 for loss of life or personal injury is insufficient to pay the claims for loss of life or personal injury, the amount calculated under 61B for any other claims will be available for that. In short, it means that for loss of life or personal injury, that limitation of liability is 618 plus 61B, with the difference that if there are property claims as well, 61B will be shared. Something very important, the states. Yes.
About the spillover provision.
Yeah.
Is it true that even if we don't have property damage claims, we can calculate the amounts and apply it to unsatisfied part of loss of life or personal injury?
It depends who you read. Different authors have different opinions. But the truth is, I believe that the answer is, as you correctly pointed out. And the reason for this is that when this provision was discussed at the conference, was not subject to much discussion. The conference said, we are following the approach of the 1957 convention. And in the 1957 convention, it said that X amount, 2,100 francs, was for loss of life or personal injury. If there were only claims for loss of life, sorry, for personal property claims, it would be 1,000 per franc. And if there were both, it was still 2,100, out of which 1,000 was saved for loss of life or personal injury, and the rest was to be shared. So in my opinion, yes, whether or not there are claims for property, you are entitled to constitute both limitation amount.
There are French cases, I think, about this question. I spoke about that in Swansea in 2022.
Okay. And the conclusion?
I don't remember.
Okay, okay, okay.
I'm very
But there are different also, but I don't have the book here, but in my book I had made specific reference to the discussions in the conference that they were following the approach. In fact, in the earlier version of this presentation, which I have shortened for time, I had precisely that 1957 provision, which explains how it was before and how it should be taken into account now. Now, this is something very important. On many occasions, ships cause damage to harbor installations and to other property. Now, they will be divided, as we will say later, racially at the same time. But states have the power to say you have to pay me first before you pay anyone else. And it is found here that says that without prejudice to claims for loss of life or personal injury, a state party may provide, so it's not automatic, you have to do it, may provide in its national law that claims in respect of damage to harbor, basins, and waterways and aids to navigation shall have such priority over claims under paragraph 1B as provided by that law. So this is very important that states do it. Like that, they will protect their own interest. Also, remember the case of the Tojo Maru that I mentioned? Article 6.4 says that salvors not operating from any ship or operating on board the ship they're salving, the limit of liability will be calculated according to a tonnage of 1,500 tons. Now, I love this article, and it's for a simple reason. That's probably what triggered my PhD. The students were asking, why 1,500? I have no clue. I don't. In one, I hate inventing when I don't know. And two, I hate leaving unanswered questions. So I'm going to go and check it. And none of the textbooks said so. Until after I said there's ground to research, until after research, I found out to the simplest of reasons. 1,500 was the usual tonnage of a ship of a salvor at the time. Limits for passenger claims. Now, for passenger claims, we don't have to deal with tonnage at all. Passenger claims are based on ship carrying capacity. And it says that is 175,000 multiplied by the number of passengers which the ship is certified to carry. Not like the Athens that is per passenger, it's multiplied by the number of passengers the ship is certified to carry. But that limit has become too low. And the LLMC convention, sorry, the protocol introduced Article 15.3 bis that says that states may provide for different rules, provided that the limit of liability is not lower than that prescribed in Article 7. In fact, I had made a proposal back in 2009 to increase the limits to 250,000. That has been followed by now by Finland, Sweden, but other countries have taken a more radical approach, like the UK, like Malta, that say that in relation to seagoing passenger ships, LLMC does not apply. In other words, leave it to others. I had this just from the region for the comparison. Albania, for example, is a party to the PAL 2002, LLMC 76 and 96. Montenegro is a party just to PAL, but not LLMC. And Slovenia is a PAL 2002 and LLMC 1996. This is a problem of having both conventions, and we'll discuss it a bit later on. And I would urge states to, yes.
Could I just ask the last one? So if Athens Convention applies, they would go under Athens, but they will go under LLMC because not all states are signatories to Athens, so.
It will be discussed, right? You will have a whole class on that. You will have a whole, that's why I decided to be very brief. The unit of account is the special drawing, right? Because I have to run now. Aggregation of claims. You see here you have 1, 2, 3, 4 vessels that have been damaged in this fire. Does it mean that you have 1 fund, 2 funds, 3 funds, 4 funds, 1 for each vessel, or 1 for all? And Article 9 says that the limits of liability determined in accordance with Article 6 apply to the aggregate of all claims which arise on any distinct occasion. So the turning point here would be, is it 1 occasion or more? And the answer to this, it depends on whether there are different acts of negligence that break the chain of causation, or there is 1 act of negligence that causes several damages. 1 act of negligence, 1 occasion, several acts of negligence that break the chain of causation, several occasions, several funds. Is this clear? Good. Limitation fund. Now, contrary to the CLC that says that if you want to limit liability, you have to constitute the fund, Article 10 says that limitation of liability may be invoked notwithstanding that a limitation fund has not been constituted. So really and truly, as I said, from the very first communication, you invoke the right to limit liability. You have that amount now, and you can start negotiations. You don't have to constitute a fund. The only thing is that since the claimant does not have security, you run the risk that he may arrest your ship. But still, you're not bound to constitute a fund. But a state party may say, sorry, Spain has done this. If you want to limit before a Spanish court, you have to constitute a fund. But that's national law. The convention allows it without. This is something quite interesting, because as any person, and this will bring us to the last points afterwards about the Baltimore case. Any person alleged to be liable may constitute a fund with a court or other competent authority in any state party in which legal proceedings are instituted in respect of subject to limitation. It seems almost like a reply to a lawsuit. But the case of the Western Regent declared what is known now the right of preemptive strike of the shipowner, and the shipowners can choose where to limit liability. The question is it an unfettered right or not? And that's where things get a bit ugly. The fund has to be constituted in the amounts we discussed in Article 6 or 7. It can be in cash, or it can be by producing a guarantee acceptable to the country, usually in the form of a letter of undertaking of a P&I club. The distribution of the fund is not equal, it is equitable, it is pro rata. Bar to other actions. Yes, Sam.
Regarding the establishing a fund.
Yeah.
So LLC does not predict the possibility directly to establish a fund before a procedure is initiated. Do you think that that is a flow of LMC? Because I know that in Western region case, court said fund can go first, then claim. But do you think that there's like amendments, or we can like rely on analogy or jurisprudence?
Let me tell you, that's a question that is really more academic than it, but I will correct myself because there can be a huge problem in this. In reality, if you see the trabajo preparatorio is not very clear on this, but the wording of the convention is in a state where proceedings have been instituted. In other words, proceedings begin, limitation follows. But the Western region was quite innovative in this wherever it is. And in reality, I favor this approach from one point of view. Imagine I'm the ship owner and I cause damage to all of you. Okay. So I said, okay, no problem. I keep on navigating. So for how long? Until my ship is arrested. And that costs time and money. And I don't want my ship arrested. So I might as well institute limitation proceedings, perhaps constitute a fund. And like that, you will not arrest my ship. I can continue trading and then we start negotiating. In other words, I don't have to wait for you to take action against me before I take the initiative to settle the thing. The question is, if I am giving that privilege, I don't want to use right, if I'm giving that privilege to choose where, should that be to your detriment? Now, there have been cases, and I have another presentation here but we don't have time, unfortunately. There have been cases in which the ship owner chooses, but of course, chooses a 1976 country. And my country is only a party to a 1996. And there are cases in which, because the fund is to apply erga omnes to all the world. Yes, but here, if you see here, it says, no, not in this one. Where was that? In any state party in which the legal proceedings have been. So the fund has to be constituted in a state party to be recognized. So I don't have a right to an obligation to recognize your 1976, 57, or 24 fund if I'm only a party to a 1996 convention. That's why I became a party to this convention, because I want the high limits. That doesn't mean that I will ignore them. There's a whole process about that. I may recognize the limit, ask you to top it up. It's a bit complex, but in reality, the ship owner should be entitled to choose, but should choose responsibly. And that will come to the last 2 points that I'm going to mention today. I come back. Let me just rush because we run out of time. So basically, what it means is that if I constitute the fund, then there is no right to proceed against my other assets. You have to proceed against the fund, and you cannot arrest my ship or otherwise. Governing law will skip it now because I run out of time. Reservations, important. As I mentioned, the 1976 convention only allowed reservations of 2(1)D and E, wreck and cargo removal. The 1996 protocol allows also claims for H&S. Why? Because the 1996 conference that adopted the protocol was the same conference that adopted the H&S convention, and they worked a lot on the linkage between the two conventions. So states can make the reservation. A lot of states have done so, and in my opinion, wrongly. Because one of the things is that limitation of liability should be there. The question is LLMC or H&S. But a number of states have just copied the text of this reservation, and the effect is that they have excluded H&S claims from limitation, but H&S convention is not important. The case of Malta, there is a bit of a wrongful, in my opinion, drafting at the beginning, but the formula of H&S is perfect, in my opinion, because they exclude H&S claims which occur after the H&S convention enters into force for the laws of Malta. So the reservation is in force already, but not applicable. So that is the way to go about it. Relationship between the two conventions, which has a strong relation to your question, there are two separate agreements. And the provisions of the 1976 convention will apply to 1996 parties only to the extent that they will help its interpretation. But the 1976 parties are not bound vis-a-vis the 1996 parties. So if you have a state like Croatia, as I mentioned, that is a party to the 1996 convention and the 1976 convention and the 1996 protocol, and there is an incident in Malta, which is only a party to the 1996 protocol, the 1996 protocol will apply. But if the ship owner constitutes a limitation fund in the 1976 convention, on what authority would you reject it if you're a party to that convention as well? Your national law may have a larger limit, but you're still a party to that convention, and it will create a problem. So that's why I said it's better to denounce the earlier convention and focus on the other. So let's finish. Sorry, I'm taking time. Practical problems. The Ever Given, as I mentioned, faced around $916 million in claims, including a claim for $300 million for loss of reputation. So that brings us to your question. See what the difference is. This was a very big ship, 219,000 tons. Under the 1976 convention, the limit of liability was around 32,185,000. 32 million. Under the 1996 protocol is 116 million, not 32. It's a huge difference. Now, Suez Canal, where is it placed? In Egypt. So the Ever Given was actually arrested by a court in Egypt. So the ship owner, to avoid the arrest, can constitute the fund. So how much would the fund be? 32 million. You know why? Because Egypt is a party to the 1976 convention. Now the problem, and that comes to your question, all those ships, etc., that come before can sue the owner, not necessarily in Egypt. It could be in any other country. So the ship owner here took the initiative, as we mentioned, the preemptive strike, but in a responsible manner. And in 1st April 2021, a limitation action was issued in the Admiralty Court seeking a general decree of limitation, under the 1996 protocol. So like that, Egypt, of course, is entitled to much more money than it would have been if it would have been constituted under the 1976 convention, and he is protected from arrest in all other countries. In fact, we had a case in Malta in which a ship broke the interconnector cable that brings power from Europe. And it was a very tough decision, not decision because we didn't go to court, negotiation. But a couple of months after, we managed to get them to limit liability. Unfortunately, didn't have the reference to the 1996 protocol, but it was clear that was the intention. The amounts were in the 1996 protocol, etc. And whilst the companies were getting their evidence to bring the action in Malta, the ship owners constituted limitation in Singapore. Singapore had denounced the 1976 convention and had become a party to the 1996 protocol, like Malta. Malta never became a party to 76, just 96. But the denunciation hadn't entered into force yet. And the 1996 protocol would have entered into force 5 days after the accident. So the regime in force was the 1976 convention. Singapore court issues a limitation decree under the 1976 convention. And we said, no way we will accept this. You have an LOU, and the applicable law in Malta is this, which brings me back to your question. And we argued matters of public policy and other issues. In the end, the case was settled out of court and actually at a higher limit than a higher amount than the limit of the conventions, even than the 1996 protocol. But we had that issue. Do you have to recognize it? And there are some cases that have seen not necessarily. And the last case is the case of the Dali. If you see here, the Dali was 95,128 tons. Now, as I mentioned before, the American system is regulated under 46 US code, and it says, without privity or knowledge of the owners, shall not, except in cases provided in subsection B, exceed the amount or value of the interest of such owner in such vessel and her freight then pending. Now, under the Dali, under the 1996 protocol, which as I mentioned, is now the law in Singapore, the limit of liability is $132,391,968. The claims go north than $1 billion, but that is the limit of liability. Now, the owners have said that the Dali itself was worth about 90 million. But after the accident, the ship's value is around 42.5 million. So the question which I will leave you is, where can or should the ship owner limit liability? You know, that would be the final question, because it is really a very tough decision. You know, and you have to weigh your risks and interest. If you limit liability under the US, which is what I think they will try, the interest of such owner in the vessel is only 42.5 million. That would be what they would have to pay, 42.5 million. But the test to break the right to limit liability is fault or privity. The Dali had experienced electrical powers in the past, etc. And it is possible that depending on the judge where they come before, can actually prevent limitation, and they end up paying $1 billion instead of 42. Or they limit liability in Singapore, which is now, as I mentioned, part of the 1996 protocol. And the test is, as we said, committed with intent to cause such loss, or recklessly and with such knowledge that such loss would probably result. That with the resolution adopted at IMO, basically they cannot avoid limitation. The limit of liability is 132 million. So they will pay more, but the risk is almost guaranteed that they will pay that amount. Here, they can pay much less, but the risk is a lot. You know? So what is the overall, then, role of limitation of liability? It provides certainty to ship owners about their financial exposure and enables the respective insurers to maintain the cost of insurance premiums. And this, in turn, allows those who are involved in the maritime industry the possibility of maintaining competitive rates, thereby benefiting the ultimate consumer. So in conclusion, in light of our discussion, it is reasonable to argue that limitation of liability, in my opinion, is essential for the maritime industry. And if notwithstanding this, like many people tend to do so, one may wish to demonize the concept. You must agree that it's a necessary evil. You know, once that in its origins was created to protect the ship owner, but now in reality protects the society as a whole. So, sorry, I passed a bit my time, but thank you very much.